trends, opportunities, and challenges, explores emerging trends, opportunities, and challenges in the IPO landscape, offering practical strategies for navigating public markets. Our moderator for this session, Ms. Vijayalakshmi L., co-convener of the infrastructure panel at CII Chennai Zone and head of sales operations at L&T Technology Services Limited. Ms. Vijayalakshmi is a seasoned professional with a deep expertise in infrastructure and operational excellence. Ma'am, request you to please come up on stage. Thank you. Ladies and gentlemen, a warm round of applause. Thank you. Please put your hands together to welcome our panelists for this session. Dr. Harish Ahuja, Head of Sustainability, Product and Strategy Development at National Stock Exchange. Ms. Shweta Kochar, Partner at PKC Consulting. Ladies and gentlemen, Ms. Shweta Kochar, Partner at PKC Consulting. Ms. Pratima, Director at B4. Ms. Subhadra Mailasamy, Managing Partner at AK Mailasamy and Associates LLP. Ma'am, over to you, please. Thank you.
Thank you. A very good afternoon to the distinguished guests and delegates of Finnovation Summit 2024. Welcoming you all for another exciting panel discussions on the trends, opportunities, and the challenges on the IPO market. Thank you, sir. Shubhrata, the organizers have been good enough to give us another 15 minutes extended timeline so that we can complete this interesting session.
Right. Good afternoon, everyone. I'm Subhadra Mailasamy, corporate lawyer. I think all my colleagues out here have put forth to you about the IPO process, what it takes, how to take about the audits. So I'm here to talk about the legal aspects, regulatory compliances, and how to protect yourself or ease out things for you during the process, right? So I will just take you through three things. One is the due diligence aspect. Next is the key legal challenges which you face. And the third one will be a kind of a practical guidance, which I would like to sum up for you all, right? Now, coming to the IPO due diligence, if you look into, it is nothing but your preliminary evaluation of your companies, which is where you start your IPO journey, which you have heard from my colleagues, which is on the aspects of readiness, which includes your financial audits, market assessments, as well as your compliance reviews. Number two, if you look into, is also engaging the key stakeholders, where you will see the entire team to be assembled, which Shweta also mentioned, which is your merchant bankers, the underwriters, you will have auditors, legal advisors, especially market analysis. So these people are very, very important. And at this juncture, I would say, it is extremely important whom you assemble as a team for you, right? Next, if you look into, is the regulatory approvals which we look into. In India, if you know, most of you are well aware, it is the SEBI, which is the Security Exchange Board of India, where your oversees the IPOs, and also the SEBI, which is the issuance of capital and disclosure requirements, which is the regulations of 2018. Under here, if you look into, you will see that mostly the companies have to file, of course, the draft reading prospectus. Then here you will see the details of the companies, the financials, their risks, and also the intended use of proceeds. Here you will see the entire legal team has to ensure that this red herring complies with your SEBI's disclosure norms to avoid any kind of regulatory pushback. This is very, very important, right? Next, marketing and roadshows. We did talk about it, I think, on the branding angle and everything Shweta had mentioned here. Here, if you look into post-approvals, you will have these roadshows which promote the IPOs to the potential, of course, the investors. At this point, legal advisors ensure marketing materials are complied with your security laws. This is very, very essential. Now, coming to the other aspect is the listing and the post-IPO compliance as such. So once you have listed, company must adhere again to your SEBI listing obligations and disclosure requirements regulations of 2015. Here you will say it mandates the corporate governance norms as well as the periodic disclosures, right? So here if you look into it, includes the disclosure norms, and in fact the managing investor relations, and also addressing certain kind of shareholder disputes. Now moving on to this, the first angle is covered. Now I'm going to talk to you about the key legal challenges here which are posed. So generally when people come to us, it is number one, it is on the aspects of regulatory compliance and market volatility. So here again, companies must comply with the SEBI ICDR regulations and the Companies Act, which plays a crucial role. So in case of failure to comply with this, it will result for your companies in penalties, delays, or even rejection of the application according to the SEBI Order number 1 of 2012. Your applications can be rejected, yes? Please bear in mind. Next is the disclosure obligations. Here, Section 26 of the Companies Act clearly mandates that detailed financial risk disclosures in the prospectus have to be put into. And in case of any kind of misstatements or omissions can lead to liabilities under Section 34 and 35 of the Companies Act, right? Next is your promoters lock-in and contribution angles. So under Regulation 14 of SEBI ICDR regulations, promoters must contribute at least 20% of post-issue capital with a 3-year lock-in. So any kind of non-compliance on this angle also can delay your listing, right? Now next is Regulation 6 of SEBI ICDR. Here it mandates financial prerequisites like net tangible assets of 3 crore and aggregate operating profit of about 15 crores over preceding 3 years. This is extremely important. And of course, your corporate governance angle. Here again, you should adhere to the SEBI guidelines where you have very clearly, they impose stringent corporate governance norms, and any kind of non-compliance under that can result in fines, as well as you will have delistings or any kind of regulatory scrutiny will put into place. Now, in the takeover angles, if you look into, if any promoter or shareholders, say for example, they are acquiring, then they should be complying again with the SEBI regulations. And in any case of escrow and banking compliance, right, the IPOs have to align with the SEBI bankers to an issue regulations, ensuring any kind of proper escrow arrangements and fund allocations. Now, next angle is your promoter details and market confidence. Now, here if you're into, it is Regulation 27 which deals here. So promoters here must definitely disclose their backgrounds, their sources of funds, and any legal proceedings which enhance their investor trust. So these disclosures are extremely important. Now, I'm coming to almost my last, which is kind of a practical guidance for success, I would say, from a legal perspective. So one is, as everybody mentions, please start early your due diligence. If you're planning to get into an IPO, start early. And here, when you say due diligence, again, it is covering financial audits, compliance records, and intellectual property rights, which is a very big must today. And of course, your existing any contracts, right? Number 2, always strengthen your governance, right? So implement robust internal controls to ensure accurate reporting and you adhere to the laws. That's on a compliance angle as well. Number 3, consider for cross-border opportunities as well. See, for many companies, if you say they explore a lot of cross-border opportunities with IPOs. So here you should understand multi-jurisdictional regulations. You should also have dual listings, and you should have certain tax implications which are vital also. So these things you should definitely consider in a nutshell before you get into an IPO in the angle of a legal perspective.